And we now call 25 CR 329, the state of Texas versus Charles Darrell Johnson Jr. That's you.
Yes, sir.
Present with Mr. West, your attorney and the state's attorney. You okay there, buddy?
Yeah.
Tonight's case is not just another courtroom hearing. It's a chilling look at what happens when violent history, denial, and the justice system collide. A man facing a serious burglary and assault charge believes probation should save him, while prosecutors say the victim barely survived. With a judge forced to choose between mercy and maximum punishment, this case takes a dramatic turn you won't forget. Watch closely because every word
And the state's attorney. You okay there, buddy?
Yeah.
Earlier, you pleaded guilty to this indictment, which alleges the second-degree felony of burglary of a habitation. A pre-sentence report has been prepared. Have the parties had an opportunity to review the report? Are there any corrections or changes to it, state?
None from the state, Your Honor. None from the defense.
Then it is made a part of the record for all purposes. There is an agreement that's been reached where whatever sentence the court assesses shall not be more than 10 years imprisonment. So we've got no less than 2, nor more than 10 years confinement. He could be placed on deferred or unadjudicated probation for up to 10 years. And he could also be placed on regular probation. I could sentence you to no less than 2, nor more than 10 years in prison, and then suspend that and place you on regular probation. But you've been on probation before, and that was revoked back in 2002. Then it looks like in 2009, you were sentenced to 6 months in the state jail for drug conviction. So that's 2 felonies convictions. And then we have a marijuana possession, which was regular probation. That's a conviction, illegal possession of marijuana, and that was in 98. And then 30 days in jail. These are misdemeanors. Possession of drugs, 30 days of marijuana. Another in 2012. There were 2 of those and different. That's odd. Look at that. That's the same exact number. That can't be right. They duplicated that. So
That's true.
That's got to be an error. Looks like you have 3 prior misdemeanor convictions of marijuana,
Yes, sir.
and then 2 prior state jail felony convictions. And all of these are the same thing. It's controlled substances.
Yes, sir.
All right. Go ahead.
Your Honor.
You may go forward.
Thank you.
If you wish.
Yes, please, Your Honor. We're going to ask the court to put him on probation, and we're going to let the court decide whether regular or straight if the court decides to probation. Looking back at his criminal history, as you see,
His time. The credit, please. Thank you.
like the court just mentioned, all of his prior criminal history is all from drug issues. The most recent one looked like the last one was in 2012 was the last conviction. So it's been quite a while since he had any problems with convictions. The biggest thing I want to point out in the PSI, Your Honor, is in the statement of interested parties that the victim of the case, who I don't know if the court remembers, we actually had a trial. This was a plea during the trial. Ms. Part already testified about what was going on. But she did state there in her statement that she does not have an objection to the defendant receiving probation. So if the court was to give probation to this individual, this defendant, the victim is already on board with that, is okay with that. Also, the last sentence there, she says she asked the court to order the defendant not to have any contact with her in any way. If you replace him on probation, you could make that an order and keep him away from her for up to, and I'm sure the court would do this, 10 years, versus if you send him to prison. We all know that he's not going to do a full 10 years, and then the court would have no control over keeping him away from Ms. Parr at that point. She can go down and get a protective order or something like that, but it's out of this court's hands. But if we were to give him probation, then the court could order him to stay away from her and make it a condition, and that if he violates it, then he goes to prison for up to 10 years of his regular probation. And if the court defers it, up to 20 years. That would give the court a bigger hammer if the court wanted to do a deferred probation. We could sentence him to a longer time if he did violate probation. Also, I think they indicated some drug treatment. I think we can get them evaluated to see if drugs are still an issue. Like I said, I know there's a history of drugs, but the last one, like I said, was not. The conviction was in 2012. So I think that probation is probably the best in a case like this.
Let me ask you, before we go forward here.
Yes.
I was thinking about some things, but everybody has reviewed the pre-sentence report.
Yes, sir.
There aren't any objections here. No. Okay.
Yeah. I know that's
All right. All right. Go ahead, Steve.
Your Honor, the facts of this case are particularly egregious. He sneaks over to her house, snuck up there on his former girlfriend. He had taken her kids out of the house prior to that in the morning, and he just starts beating her, ends up choking her out several times where she passes out, and she's eventually able to escape. He flees, and then the kids suddenly show up again after he drops them off down the road. Again, she could have very easily died in this situation, Your Honor. I believe it warrants every bit of the 10 years. And even now, the defendant continues in his PSI to contradict the evidence that was presented in the testimony for both her and what her kids, the statements her kids had given as well. He continues to not take responsibility. And in fact, he says, I went ahead and went with it because he said I could get 20 years and I didn't want 20 years. So I still don't have him acknowledging that he did this. And he's still not taking responsibility, Your Honor. And I believe he deserves no less than the 10 years, Your Honor.
Any response?
Your Honor, we can let Mr. Johnson testify about that if you don't mind. I can call him as a witness about
Okay.
that.
Okay. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Go ahead, Mr. West.
Mr. Johnson, part of the indication says here that you didn't break into her house, and you still believe that you did not break into the house, correct?
Right.
Okay. You did go in the house uninvited, correct?
We went into the house.
Hold on. Hold on. Hold on. Hold on. It's all about what the facts are.
Yes, sir.
I asked everybody, is there any changes or corrections to the pre-sentence report? And there were none. Let me read the second line of paragraph 2 under police version. The second paragraph, on the above day, Charles Johnson snuck up on his girlfriend, Nisha Parr, as she was trying to enter her residence in Beaumont. Johnson then forced his way into the house behind her and began assaulting her. I'm sorry. He forced his way is a violent act. Okay, let's correct the record. You weren't invited in. This says you forced your way in, which means it was without her volition, and then assaulted her.
Your Honor, this is not his statement. He doesn't. What I'm getting at, I was getting to question him, is that he was there. They went in. It wasn't a situation.
He's saying the police are wrong in this report.
Well, the
Is that what he
police.
said? Well, no, let's come on.
Well,
Let's
let's-
get it straight.
yeah.
Is this nobody objected to this? That's what makes me
Because that's-
unsettled. I've got to make my decision on the facts. No one objected to this. This is here. He forced his way in.
Your Honor,
Is this wrong or not?
that's the police version. I can't say their version is what they put down as wrong.
Do you debate their version?
We do. His
All right,
they're
but
different.
That's what, well,
It's like we can't
but
object to what the police
you need
say.
to- if there's a big difference between what is being said here by the authority that wrote this and you, point it out to me. I mean, I do read this, but sometimes
Also, Your Honor,
these things pass by unless they are emphasized, because this is a big problem right now. He says one thing, the police are saying another. I'm going to be the fact finder. Go forward.
Well, Your Honor,
Go
we
forward.
had a trial, and the defendant or the victim even testified to that. Okay, but his position is that, and I'm trying to get a question, is that he did go in uninvited, kind of forced his way through, but it wasn't a situation where he broke a window or broke a door or went in that type of way.
He was convicted of intentionally and knowingly entering a habitation without the effective consent of the owner with intent to commit assault.
Okay, but Your Honor, sometimes with non-lawyers, they don't understand the difference between breaking into and going out without consent. I think
Facts
that's
are
what
the facts.
the facts.
That's all I want. It's facts.
Facts are facts, but I think when you ask, did you break in? He's going to say no, because most non-attorneys to be able to deal with this don't consider just going in without
I've
permission.
done this for 40 years. I know what you're saying.
Okay, all right. That's what I'm getting at. So I think that explains his version of it, that he didn't break into. I think that's going into it. Now, whether he went in with permission or not, I don't think he went in with permission. I don't think anybody believes that.
But what we're trying to get to are the facts. What's the truth?
Right.
And somebody's version may be different from the facts. Go ahead.
Okay. Well, I think the facts are, like I said, the facts are the
I'm a
facts.
fact finder.
He went in without permission, and some bad things happened. I think there's no question about that. Okay. The question is in his report. I'm trying to correct his version here, or let him explain to it that it wasn't that he broke into, because I think they asked him when asking the defendant if he broke into the victim's house. The defendant said no. Okay. So I think that's the issue here. Is I don't believe he broke into, meaning broke in a door, broke in a window, something like that. But he did enter. If they would ask, did you enter without permission? That'd have been a different question. Okay. So I just want to make sure the court that that's correct. Okay. And it's not an objection to it, because that's exactly what all was said. We're not objecting to any of that, because that's true. But I think the court needs the explanation of that's the difference there.
And it goes, upon entering the residence, this state, he began assaulting her and dragging her through the house by her hair, using his hands to strike her and threw her body about the room. Then used his hand at the front of her throat, grabbed her trachea, then squeezed her throat, cutting off her breathing and causing her to pass out. So does that look like he was invited and welcomed in there, or he snuck in behind her and immediately began to assault her? That's not forcibly entering.
When, Your Honor, there was testimony from the victim that he was in no way invited. In fact, he showed up behind her as she was going in through her garage and ran up on her.
Do you agree with that?
Went into the house.
Yes.
Okay.
But I'm just saying that the phrase broke into, I think that I don't want.
We're semantics now. Well, I'm talking about he committed the crime of burglary and she was assaulted.
That's why I was.
Let's move on to what the points are. We're bogged down on how he entered the building, but it was for no good purpose.
It was not with permission. It was not for a good purpose, right? But it wasn't a situation where he broke into. I think so. I don't want the court to say that he lied here, because I think his version is that he didn't break into because he doesn't understand what the law says. Okay.
Wait, did he enter her home without her permission?
Absolutely.
Okay. So he trespassed. Okay, that's a crime.
I know. We're not saying that he
To
didn't.
get in, he committed a crime.
We didn't say that he didn't commit a crime.
Let's move forward.
Okay, all right. But like I said, I like to go back to the point where even the victim in this case indicated that probation would be good for him, or she would have no objection to it. And I still think that probation with a restriction to keep him away from her, and all the conditions of probation to making sure he lives right, would be good. I know he has violated probation in the past. However, in the past, it was a drug-related issue, and it's been quite a while since his last probation. So I think this is the type of case that this would keep him under the court's authority, keep him under the court's eye through the probation department. That this would be helpful for this both the victim and the defendant in this case.
So,
Your Honor, the victim here could have died multiple times. He passed out several times. And by the grace of God, she didn't end up dying and was able to escape. Who knows if she wasn't able to escape, and one of the times when she has to go to the kitchen, what would have happened in the end. So sometimes we have to protect the victims also. In these types of relationships, we know they tend to want to be lenient on the defendants. However, that's a dangerous situation, and what he did was extremely dangerous and horrible. And with those kids, again, dropping them back off over there, and they have to see the house being completely busted up, knowing their mother has been strangled and beat. I believe, again, every bit of that 10 years is warranted in this case.
what would you like to say, sir? This is your time.
It's fully telling me to the thing that happened.
What happened?
You going into-
Because he's saying something different than he is.
I went into the house without permission.
And then what?
Yeah, like, no price.
Then what? Oh, she punched you first?
No, sir. I grabbed her phone and she grabbed me and we started wrestling over the phone basically. I had no intent to try to kill her or harm her or do anything.
Well, it says you dragged her through the house used your hand to squeeze her throat, cut off her breathing, causing her to pass out. When she would regain consciousness, you would continue your assault and squeeze her again. This assault went on for several hours before she was able to escape her house, running to a nearby business where a citizen was able to contact the police for her. She sustained injuries in the form of abrasions, scrapes, cuts, and bruises all over her body. Are you kidding me? You're going to stand by what you just told me, that really nothing, you didn't intend to do anything, this was no big deal, in spite of what this says? You don't understand and appreciate the seriousness of what happened in this person's home where she's supposed to live in peace?
Yes, sir.
Okay. Here's another statement that I don't understand that you made to the probation office. When asked how you're going to do if granted probation, you stated, "I'm going to do good. I'm not really a drug guy." Really? What are you? How many convictions do you have of drugs?
It's 3.
Wrong. Do I know more about you than you do? No, in 98, you were convicted. 1 year adjudicated probation of illegal possession of marijuana. In 2003, 30 days in jail. In 2012, 30 days in jail, marijuana. In 30 days in jail. In 2002, let's talk about the felonies now. 2 years stay jail, probated for 5 years for drugs. That's 5. That was revoked, and you received 6 months state jail. And then in 2009, 6 months in the state jail. 2 felonies and 1, 2, 3, 4 misdemeanor drug convictions. But you're not a drug guy. You don't have an answer to that.
No, that's
Because it's just nonsensical.
I'm speaking about recently.
Oh, recently, you mean since you've been in jail? You don't use marijuana in
The
jail.
last 12 years, I haven't been.
Let me ask you this. This event, was this caused by drugs?
No, sir.
So this is the way you act when you're sober?
No, sir.
Yes, it is. The defendant has pleaded guilty voluntarily. He is mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilt, your plea of guilty from State's Exhibit 1 admitted to your hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt, and I am following this agreement. The agreement is whatever sentence shall not exceed a cap of 10 years imprisonment. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You can leave.
Ma'am.
You can leave.
You step outside, ma'am.
Step outside. This is what we call justice.
Yes, sir.
Your rich criminal history. You have a rich criminal history. You're held in contempt of court. Get her. She'll be. You can't make an outburst in court.
Get it.
You're going to be given credit for all time you have served, but you can't invade somebody's home and assault them.
Yes, sir.
And with your rich criminal history, we knew better.
Yes, sir.
All right. Okay. Anything else to add?
No, Your Honor.
That is all. You can't make an outburst in this court.
I'm sorry.
You can be held in contempt of court up to 6 months now. Are you related to somebody here?
I'm sorry, sir. I apologize.
Or that's okay. Are you related to somebody? Who do you know? This man?
Yes,
How do you know him?
sir.
He's your brother. All right. You were here and you heard what this was all about, right? Did you hear? Okay. It's a very serious thing.
Yes, sir.
And his criminal history was, but here's an issue when he gets out, the family needs to help with this. It's still a drug issue that he's struggling with. And he says he doesn't have a drug problem, but I think a lot of this is based upon what is out there. People don't know what's out there. What the people are manufacturing cause folks who take it to do odd things. And it's very serious. Some people are dying out there right now. for some of this. But I think you're a rational thinker when you're not inebriated with drugs. And I just wish that seems to be your problem. But then you tell me I don't have a drug problem, but you've got all these convictions for drugs. But it's one of these things that the family is going to have to help you. John, I want you to talk to me about what you might be able to figure out in what plan you might be able to do to put him into a facility, which this court might consider doing before this term is completed. You know what I mean?
Yeah.
Because he needs help.
Okay.
And the family seems to be supportive of him, but you've got to be firm that his actions can't be tolerated. And it's Christmas time. It's supposed to be where the family gets together and enjoys life. And they're not with you. You're not with them. And but there's a
What we're watching is the danger of minimizing violence through semantics. Breaking in versus entering without permission might sound like legal hair splitting, but the facts tell a much darker story. Forced entry, immediate assault, choking until unconsciousness. These aren't misunderstandings, they're red flags. And when the defendant continues to downplay what happened, the judge isn't just frustrated, he's alarmed. Let's be honest. If someone can't acknowledge the severity of what they did, how can a court trust them outside prison walls?
way to avoid that. Okay. Thank you. Let her go. Yes, I am.
Yes, sir.
This case ends exactly where the evidence led. The judge followed the sentencing agreement, imposed the maximum 10 years, and made it clear why violent conduct, lack of accountability, and a long criminal history left no room for probation. This wasn't about punishment alone. It was about protecting a victim who nearly lost her life and sending a message that denial does not outweigh facts. Justice here wasn't emotional, it was deliberate. Backhand index pointing right if you found this case as shocking as we did. Hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful, real courtroom breakdowns you won't see anywhere else.